Picture this: America's most widely owned rifle, the AR-15, suddenly being stripped of its Second Amendment protection. What would happen to the millions of people across the country who own these firearms? This isn't some far-fetched scenario. Right now, the Supreme Court is dealing with this exact question. Let me walk you through what's going on with this incredibly important case. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Alright, let's dive into the details. So, let's get into what we're covering today. There's a major legal battle over rifle restrictions that's now asking for Supreme Court involvement. The case is called Vermont versus the Cook County. The people bringing this lawsuit are everyday citizens living in Cook County, Illinois, and they're teaming up with gun rights groups like the Second Amendment Foundation to fight back against local rules that make it illegal to buy, sell, transfer, or even own what the government calls assault weapons. This lawsuit is trying to take advantage of something Justice Kavanaugh said recently after the court refused to hear the Snope rifle ban case last term. In his statement, Kavanaugh made it clear that the Supreme Court would need to tackle the rifle ban issue soon, possibly within the next term or two. The people filing this petition are basically saying this is the perfect opportunity to make good on that statement. Other gun rights organizations from different states, like ANJRPC, which is fighting a similar ban in New Jersey, have now filed documents with the Supreme Court supporting this case. They're all saying the same thing. It's time for the highest court in the land to take on one of these rifle ban challenges and put an end to these kinds of state restrictions everywhere. Let me explain how we got to this point. Back in 2021, this lawsuit was filed in a federal court in Chicago. The people suing argued that the county's ban violated their Second Amendment rights. Then in 2024, while the case was still going through the courts, Illinois went ahead and passed its own statewide ban on assault weapons that basically covered the same ground as the county law. That statewide law is called the Protection of Illinois Communities Act, or PICA for short, and we've talked about it a lot on this channel. Around that same time, the Seventh Circuit Court of Appeals ruled on another case called Bios versus Neepville. In that decision, they upheld the Illinois law by saying that AR-15s were too military-like to be protected by the Constitution. Their reasoning was that because these rifles are useful for military purposes, states can restrict them or ban them completely. The lower court sided with the county and issued a summary judgment in their favor. Then in 2025, just after the Snope case was turned down, the Seventh Circuit backed up that lower court decision. They relied heavily on the Bice ruling, basically treating AR-15s like they're just civilian versions of M16s. According to them, these are military weapons, which means they fall outside Second Amendment protection. That's what brought this case to where it is now, asking the Supreme Court to review the actual substance of the case. Remember, the district court already decided in favor of the county and their restrictions through summary judgment. In this petition, the people filing are asking the United States Supreme Court to get involved, sort out all the contradictory decisions from lower courts, and finally settle whether Americans have a constitutional right to own these kinds of rifles. Their argument is that different circuit courts are completely split and totally confused about how to apply the Supreme Court's decisions in Heller and Bruin. Honestly, I don't think these lower courts are actually confused at all. They're just flat out ignoring the Second Amendment and what the Supreme Court has already said in cases like Heller and Bruin. The people filing this petition are saying the Supreme Court needs to make it crystal clear that all firearms, including semi-automatic rifles, are protected arms under the Constitution. In their petition to the Supreme Court, they've included surveys, manufacturing numbers, and sales information proving that tens of millions of AR-15s are out there in circulation, owned by people who follow the law. They point out that Cook County and the Seventh Circuit are hanging their argument on the idea that AR-15s are military firearms. But here's the thing, Heller never said that guns can be banned just because they're useful to the military. The only historical limit that might exist, based on Supreme Court precedent, is potentially on weapons that are both dangerous and unusual. But AR-15s are the opposite of that. They're extremely common, widely used, popular, and overwhelmingly owned for legal purposes. This whole analysis about being useful for military service that the Seventh Circuit and other courts have been using was never part of Heller or Bruin. It was never mentioned as the right way to look at things, so the Supreme Court should completely reject it and throw it out. They also highlight how all these laws have been passed in direct defiance of Bruin. Some states pushed these bans through right after Bruin came down, basically giving the Supreme Court the middle finger after that landmark ruling. Because of all this, they're pointing back to what Kavanaugh said in the Snoke denial, reminding him that he promised to review one of these rifle ban cases within a term or two. They're saying this is the ideal case, the perfect opportunity to look at a county law that bans these rifles and related items. There's also a similar state law that was used to justify upholding this ban. This case is on the final merits after a summary judgment was granted, making it the perfect vehicle to finally deal with this issue. This point is also emphasized by another gun rights group, RPC, in the amicus brief they filed with the Supreme Court for this case. They're currently fighting a similar statewide ban in New Jersey that also bans rifles and magazines. In their amicus brief, they argue the Supreme Court should take this case because it would affect their challenge in a different area dealing with a different state ban. But it would also address all the other state bans that have been tied up in the courts going back and forth for years. Everyone has been waiting forever for the Supreme Court to finally tackle this, and this is the right case to do it. They mention that just 7 days after Bruin was decided, Delaware passed its own ban on commonly owned semi-automatic firearms on June 30th, 2022. After that came a wave of similar bans in 2023 from Illinois and Washington, and of course that same year saw the passage of the Cook County law that's at the center of this petition. They're making the point that states just aren't getting the message, and until the court directly takes on this issue, the defiance is going to continue. ANJRPC points out in their amicus brief that justices like Thomas and Kavanaugh and others have previously said it might be time to review rifle bans and magazine bans. ANJRPC is stating that the time is now and this is the case they need to take. They wrap up their amicus brief by saying that the record from the New Jersey case shows the constitutional damage being done by letting most courts, hearing these cases, go completely off track with the same kind of balancing test that dominated for 12 years before Bruin. Because of this, the court has an excellent opportunity with this petition to stop that derailment from happening. From New York to California, this case sitting before the Supreme Court asking for review is critically important and necessary to knock down these state bans. Up until now, the Supreme Court has dodged the rifle and magazine ban question like it's the plague. But we know that Kavanaugh said last term that it's going to be time soon for them to address these rifle bans and that they would do it within a term or two. We're about to find out whether Kavanaugh's promise was just empty words or if they're actually going to review this kind of rifle ban within that time frame. So once again, there's a critically important case currently waiting for the Supreme Court to decide whether they'll review the final merits of a case dealing with a rifle ban. We're going to watch how this unfolds and see if the Supreme Court finally decides to take on this crucial issue. As more information comes out and this situation develops further, I'll keep you guys updated. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one. But as always, thank you so much for all your support, and never forget that this nation was built by rights and reloads, and this nation will be maintained by rights and reloads.